From a man facing serious allegations in a shooting case,
we will concede that there will be evidence that he was present at home when his mother's house was shot up. But that's it. There's no evidence that he left that location to go shoot up anybody else's house.
To another waiving her right to a preliminary hearing while also facing an assault and battery charge.
Actually, I want to plead no contest.
We're not pleading
Okay.
yet.
Okay. Yeah.
These cases show how Judge Simpson ensures accountability, starting with Mr. Horn, who is facing serious allegations in a shooting case tied to retaliation and escalating violence.
Court does call the case People versus Michael Horn.
Absolutely, for the people.
Your name, sir?
Michael Horn.
All right, what are we doing?
Yeah, we're asking this matter be set for exam.
Discovery complete.
Yes, Sean.
People have their witnesses available the 25th.
I'm sorry, Your Honor.
Would people have their witnesses available the 25th?
We'll try, Your Honor.
Preliminary examination in person, March 25th, 2025, 9 a.m. That's before Judge Moore.
May I address bond?
You may.
Yeah, this case was reissued after a dismissal. Not any objective reason why the bond should be so high, $500,000. I believe there's any witness or concrete evidence that my client fired any shots, or is there any witness or concrete evidence that my client was the driver of a car in which shots were fired from? Understanding we're going to have a preliminary examination in this matter, but from all the hours of body camera footage that I was able to review, witness statements, and I know cases can be made by circumstantial evidence, Your Honor, but I don't even see it circumstantially here. And when looking at my client's youthfulness, I don't think he's a flight risk. He has family in the courtroom, his grandfather, his girlfriend, his child. I think the court can look at a lot less restrictive means, house arrest, tether, to ensure the safety of the community and that he will not flee, Your Honor. But do not think that my client is a flight risk. And without concrete evidence that he fired shots at anybody or drove the car knowing that shots were going to be fired at anybody, I don't see how he's a danger to the public, Your Honor.
When you say it was dismissed, I mean, it's a reauthorization.
Yes, Your Honor.
That's correct, Your Honor. When it was up for exam initially, the officer in charge was out of town. So the case was dismissed at defense request and we did refile it.
Got it. Okay. Response to the motion.
Your Honor, I do think the bond is appropriately set. We did put in our bond information form that this was a case involving shooting and the potential for shooting at a building. I do think that the facts in the case will be borne out, hopefully, at the preliminary examination to give all of the factual basis for this case. This shooting on Andrea Street is believed to be in retaliation for a different shooting that was related to something else where this defendant was positively identified at that prior one on Knollwood. So we are asking that the court continue the bond and keep that earliest possible preliminary examination date of March 25th.
Yeah, may I respond?
Yeah.
So it seems to be that the people's theory is that because my client's mother's house was shot up and he was present when it was shot up, he must be responsible for this other shooting, although no witnesses put him at the scene of that shooting, Your Honor. And I don't think that
You're saying
at the second shooting.
Yeah.
Yep. We will concede that there will be evidence that he was present at home when his mother's house was shot up. But there's no evidence that he left that location to go shoot up anybody else's house or drove anybody to go do that. And because of that, I don't think a $500,000 cash shooting bond is fair. Yet.
Anything else, Ms. Lunder?
No, Your Honor.
All right. Oh, okay. So the first shooting, when did that allegedly take place? What?
Approximately an hour to hour and a half earlier that night. And
we're not talking days.
It's very close in time, is my understanding, Your Honor.
Okay.
The car involved in the shooting was stopped. The second shooting.
The second. Okay.
Was stopped that night by law enforcement. My client wasn't in the car. No, he was not.
Okay.
But the car was registered to him, Your Honor. That is be a fact that we will be conceding at exam and trial.
So I'm not jumping to any. The car that was involved in the second shooting belonged to the defendant.
Yes, Your Honor.
That approximately an hour before, correct me, but sometime just shortly before that, the defendant's mother's home was shot up.
Yeah.
Yes.
And Counsel, you said he was present at the home when his mother's house was shot.
He arrived after the house was shot up.
Got it.
He's on body camera, but he's not on body camera leaving in the car that is caught after the second shooting, the shooting we're here for. He's not in the car.
All right, I got you. I think. All right. Well, what I'm going to do at this time is I'm going to deny the request for the bond reduction. I'm going to leave bond set where it is. We're 10 days out or whatever it is from a preliminary examination. Let all those facts come out, and then let Judge Moore make a decision as to proper release.
Yes, Sean. Thank you.
This case reveals just how dangerous reckless decisions can be on the road. Here's Mr. Manor, facing charges for drug possession and driving while intoxicated.
Court calls case People versus Craig.
Craig Manor.
Okay, 2 charges. Added count 3 of use of a controlled substance, a 1-year offense. Added count 4 of operating while visibly impaired, a 93-day offense. Upon his successful plea to counts 3 and 4, counts 1 and 2 would be dismissed. That
is correct.
That's the court's full understanding of the agreement.
Yes, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Craig Manor Jr.
Has he signed an advice rights form?
I believe so, but I can have him sign another one, Your Honor. I apologize. I had thought he did it previously. Thank you. I apologize. You have, okay. Will you just sign it again? Thank you.
Sir, it is this court's understanding you're going to be pleading guilty to 2 charges. Is that your understanding?
Yes, sir.
First of all, the court's understanding you're going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, sir.
It's also this court's understanding that you're going to be pleading guilty to an added count 4 of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail. Court could order 93 days in jail up to $300 fine plus court costs. The court could order any rehabilitative services or community service the court deems necessary. The court could order your vehicle forfeited, could order your vehicle immobilized. Court could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. I also have to advise you, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. Do you understand that?
Yes, sir.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes, sir.
To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will and because you believe that you are indeed guilty. February 13, 2024, at the location of westbound I-94 near State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Were you in possession of a mixture containing fentanyl?
Yes, sir.
Did you know that you were in possession of that?
Yes, I did.
And had you used it?
Yes, sir.
All right. On that same date, at that location, were you operating a motor vehicle?
Yes, sir.
Prior to that operating that motor vehicle, had you consumed alcohol and ingested the controlled substance?
Yes, sir.
All right. Were you stopped by the police or was there an accident?
I was pulled over already. I had a flat tire.
So you were on the side of the road, the police arrived?
Yes, sir.
All right. Were you ultimately arrested?
I went to the hospital that night.
You went to the hospital and there was a blood draw?
Yes.
All right. And what were the results of that blood draw?
I was positive for alcohol and opiates. Fentanyl.
It was so the fentanyl did show up in your blood test results?
Yes, yes, sir.
Or its derivatives. And what was the blood alcohol
It
content?
was
for?
0.1021.
Thank you. Sir, do you have any reason to dispute those results?
No, sir.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol and your ingestion of the fentanyl?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be April 1st, 2025, 9 a.m. before Judge Valvo. And with its conditions will continue. Thank you.
Now we have Ms. Burberry, already in legal trouble, now facing a drug possession charge that led to a guilty plea and a criminal record. Let's see how the judge handles this.
Court calls the case of the people versus Amy, is it Burberry?
Cheryl Foster Tucker on behalf of Amy Burberry.
All right, what are we doing?
Your Honor, we do have a resolution.
Oh,
Yeah.
well, I guess, yeah. Plea form indicates that the defendant would be pleading guilty to an added count 2 of use of a controlled substance. The 1-year offense upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Has she signed an advice of rights?
She did, Your Honor.
May I have her sworn?
Raise the right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Ma'am, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. Is that correct?
Yes.
All right, that is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes.
Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty?
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
Yes.
Is that correct? You've signed the advice of rights form, correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you? You're doing this voluntarily?
Yes.
Of your own free will? And
Yes.
because you believe that you are indeed guilty?
Yes.
January 18, 2025, at the location of 272 Clark Street, City of Saline, Washtenaw County, State of Michigan. Were you in possession of methamphetamine?
Yes.
Did you know you were in possession?
That's,
Yes.
yes.
Had you used it?
Not that day.
So you had used it when?
Like a day earlier.
Pardon?
A day earlier.
Okay, the day before, so on the 17th?
Yes.
All right. And you knew what you were using at that time was methamphetamine?
Yes.
I need a verbal
Yeah.
response. Counsel, has the court complied with the court rule and would it be proper to accept this defendant's plea?
Satisfied, Your Honor.
We'll accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be April 15, 2025, 9 a.m., 14A3 District Court before Judge Freshour. Bond with its conditions will continue. Thank you.
Your Honor.
Thank you.
This time, Mr. Leon is back in court, dealing with the fallout of his bad choices, from writing bad checks to committing larceny. Let's see how that plays out for him.
Court calls the case, People versus Frankie Leon.
Assistant Public Defender Jay Bellinger on behalf of Mr. Legal Coaches. Please state your name for the record.
All right, I have before me a plea form. It indicates that the defendant would be pleading guilty to the charge of larceny, 200 to 1,000, to 1 year offense. Upon a successful plea to that charge, that's the added count 3. Count 1 would be dismissed.
It should say 1 and 2, Your Honor. I'm sorry.
1 and 2 would be.
I apologize. I listed them, but if I
Yes.
one answer, I apologize.
Okay. Counts 1 and 2 would be dismissed. There is further the agreement and no delayed or deferred, indicating defendant has made restitution in the form of a bond to the court for the full amount. Is that
Yes.
Yes, Your Honor.
my case? All right, real good. All right, that's the court's full understanding of the agreement.
Ours as well, Your Honor.
All right, very good. May I have it?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Frankie Leon Jr.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is a subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
Yes?
Yes, sir.
All right. And understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct? Question regarding any of those rights? Who's raising their hand? Well, hold on. Does anybody know what she's trying to clarify to the court?
Your Honor, I will be addressing bond after this. I will be asking to address bond after this, Your Honor, after the plea, but for purposes of the plea, I don't believe there are any questions pertaining to the plea itself.
I'm here, Job.
Who are you? Is everybody talking to me? All right. So as to both sides, despite the hand being raised, you think that I can proceed with the plea?
I do, Your Honor.
I don't see any issues moving forward.
All right. Sir, you understand the maximum penalties, correct?
Yes, sir.
All right. And you signed an advice of rights form, correct?
Yes, sir.
Do you have any questions regarding any of those rights?
Yes, sir.
All right. Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up the right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will,
Yes, sir.
and because you believe that you're guilty of this offense?
Yes, sir.
October 8th, 2023, at the location of 771 Airport Boulevard, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do in relation to First Merchants Bank that makes you think that you're guilty?
Say it again.
What did you do in relation to First Merchants Bank that makes you think that you're guilty?
Sign my name on the check.
I'm sorry?
Signed the check.
Okay. You're gonna have to give me a little bit more detail than that.
Your Honor, if I may,
Yes, please.
was there a valid account that you signed the check on?
The person told me it was, but I'm assuming it wasn't.
Did you
Yes.
and you came to find out that there was no active account on that?
Correct.
Did you write another check on that account? Was there more than one check that was written?
It was just them two.
Okay, so there were two.
I believe so. Yeah. Yes.
Okay,
Well, we need a little bit more than that. So
I understand.
then
Your Honor.
you went,
Yes.
so after the first check, you knew there was not a valid account. Is that right?
No.
You didn't?
No, I didn't. I didn't really know. Didn't know really much about bank accounts at the time. Or none of that.
So let me ask you this. The 2 times that you went in,
I only went in once.
you only went to the bank 1 time?
I ain't going to the bank at all.
This,
It's Costco, I mean. Okay.
As the check.
7, yes. So you went to Costco,
Yes, sir.
you wrote a check. You did that twice. Is that right?
Yes, sir.
The second time that you went in and wrote the check at Costco, pardon?
would have had to have known the time he's going to take the plea today. Sorry, Your Honor.
The second time that you went in, did you know that the check would not be a valid check? Pardon?
Yes.
Okay. And so in doing that, you attempted to get goods from Costco's that you hadn't paid for because you knew the check was no good. Is that correct?
Correct.
Correct? Okay. Was the total amount of the goods that you received, was that in excess of $200? Yes? All right. Yeah, counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
We are satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation is ordered at 14A1 probation. Sentencing in this matter will be
April 9th.
April 9th, 2025, 9 a.m. That is before me. As to bound.
Your Honor, Mr. Linyoon's wife is in the court today. The family is prepared to move to North Carolina where he has some jobs lined up. He did give me an address where he would be staying. He is asking for permission to move to that state as early as today. I did talk to him about the distinct possibility of you saying yes and no. I talked to him about him meeting with probation and setting up a PSI. I talked to him about the potential of being able to do the plea via Zoom if the court so allow. He does financially support his entire family. His wife has made it known to me that she cannot do this move without him. He is asking again for the court's permission to move to the state of North Carolina. I did talk to Ms. Londy about this. She said she'd leave it up to the discretion of the court, but she had otherwise no issue with it.
Is that correct, Ms. Lonnie?
Yeah.
So what I'll do is this. after the defendant has his pre-sentence interview, I will give the defendant permission to move to North Carolina.
Thank you.
In all other aspects bound.
Unlike the others, this last case centers on Julia Martinez, who is facing multiple legal issues, including an assault and battery charge. Now she's waiving her right to a preliminary hearing as she prepares for trial.
Ms. Martinez, can you get yourself unmuted and state your name?
Devin
Okay.
Julia,
Go ahead, state your name.
Devin Julia Martinez.
Thank you, Judge. Speaking of Ms. Cannon on this matter, my understanding is she was intending to do a waiver of this to circuit court. Ms. Cannon has signed the document, but she was thinking Ms. Martinez would be in person and she could sign it that way.
All right. Ms. Martinez, is your understanding that you're waiving your right to a preliminary examination?
Yep.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed or the offenses alleged were committed and that you committed them. You understand that?
Yeah. Well, actually,
you
wanted to
understand-
plead no contest.
We're not pleading
Okay.
yet.
Hold on.
Okay. Yeah.
You may be pleading no contest in circuit court. Is that you think?
Yeah. I believe so.
Okay, so you understand that you're waiving your right to a preliminary examination and you're headed to circuit court. You understand that?
Correct.
And that means you're not gonna have that hearing in here,
Correct.
down here.
Right.
Got it?
Right.
Okay. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for March 31st, 2025, 1:30 before Judge Hamud.
Thank you very much, Judge.
Thank you. Bond will continue.
We were hoping.
Thank you, Ms. Martinez.
Hoping
Pardon?
to lower the bond, possibly. I did ask
I don't
for that.
have notes to that effect, but Your Honor, based on my client's request to discuss bond, I'd ask the court to consider a reduction. It sounds like she is intending to resolve this matter at circuit court with a no contest plea. So I ask the court to
Doesn't she,
consider.
I think you have other matters pending, don't you?
Just that that will be resolved in the final trial on the 20th. Yeah.
But you're being held on something else?
On the 20th, it will be resolved.
Okay, who's that before? Pardon?
Judge
Valvo?
Yeah. But she has another, so
She wanted to see
Ms.
how this
Martinez,
works.
when you say to be resolved, what do you think is gonna happen on the 20th?
Nothing, no charges will be pressed, I believe.
Okay, let me ask you this. Are you in Judge Valvo's mental health court?
No,
Is that where, no? It's just a straight case before her?
yes.
I don't know anything about that.
Either do I, Your Honor, what I might suggest is if that case is resolved on the 20th, Ms. Cannon can speak to the prosecutor with Judge Hamud and see about potentially doing a step in order to have her released if that works.
She does have a hold out of Mill Valley for possession of, and I think we did discuss the assault and battery out of 15th District Court. It
That's
looks
the
like
one point. Yeah, it's not true and it's gonna be dropped. So, yeah, I was hoping. What?
Okay, and so here, what we'll do, Ms. Martinez, I'm gonna deny the request to change your bond at this point. If, and go with Mr. Feaster's suggestion, if your case resolves on the 20th, they can get you can get your request before Judge Hamud regarding your release.
Thank you so much.
Okay, all right, thank you.
I saw you on the
Okay.
news, by the way. I saw you on the
You
news.
what? You saw me on the news?
You looked awesome, yeah.
Thank you. I don't get that much, so I appreciate that.
I have some good
All
endeavors
right.
coming up with Dr. J too, so I'll see you later.
All right, take care.